We have more now on our headline oil spill in Singapore story. Now, Transport Minister Chee Hong Tat says the insurer of the damaged bunker vessel has a limit of around 8 million Singapore dollars under the law. Beyond that, claims can also be submitted to the International Oil Pollution Compensation Fund.
This international fund has a much higher limit. It has a limit of 362 million. So the amount has been set based on what they assess will be necessary to deal with oil spill incidents. And you can imagine in the past there have been many of these, even at a much more massive scale than what we are experiencing in other parts of the world.
With the oil spill reaching Johor, Mr. Chee says Malaysia has been told it can also submit claims to the fuel tanker's insurer. Now, he adds Singapore remains ready to help Malaysia and Indonesia with this incident.
Singapore, Malaysia and Indonesia have long-standing arrangements and procedures to respond to oil pollution. We also established a revolving fund committee in 1981 to enable quick response to such incidents, which could happen in our waters or it could happen in the waters of our neighbours.
Well, we have more now on this, and with us is Tan Shui Ting. She is a maritime lawyer with Sharp and Jagger LLC. Ms. Tan, very warm welcome to the show. First of all, Singapore has raked up huge expenses to clean up the sea and our beaches. We saw the pictures there, the booms. These are heavy, heavy machineries and heavy, heavy equipment. Who's going to pay for it?
Well, generally, these these costs are going to be paid for by the insurers of the bunker tanker. The bunker tanker is prima facie liable to the Singapore government for repaying all the costs incurred in cleaning up, and the insurers of the bunker tanker may then seek to recover these costs against the owners of the dredger and the insurers.
Right. So is that a simple process, or is it pretty complex in terms of the time and the logistics behind it?
Oh, it's not simple at all. It's usually very complex. Yeah. It takes a long time, and usually such claims can take years and years.
Years?
Yes.
Oh, okay. So we're looking at the long haul here. Now, a question on the fuel tanker Marine Honor. That's the one that leaked the oil into the sea. Now, that was the stationary vessel. But then you have this other vessel that hit the Marine Honor. Why then is the tanker Marine Honor the one that's liable instead of the one that, lost control apparently and damaged it?
Well, because the short answer is that the stationary vessel was the one that was carrying the oil and the one that leaked the oil into the sea. Hence, the government will look to the owners of that vessel for compensation. And this would simplify the process for the government to bring all its claims against one vessel instead of looking to two vessels.
So does it mean the vessel that actually hit the tanker gets away scot-free? Because it doesn't seem like a very just system. That's
very unlikely. But the insurers of the two vessels will then have to negotiate the claims, and the insurers of the stationary vessel can, as mentioned earlier, look to the insurers of the moving vessel, the dredger.
Right. So that's still in play, so to speak, right? It's not completely off the table.
Yes.
All right. So you said it's going to take a long process, could be even years. When it comes into gauging who gets what, how much is paid to who, what are the kind of facts and the details that you'll be looking at, or they will be looking at, to determine the claims, the amounts?
So generally speaking, they would be looking at all the circumstances surrounding the incident. Usually in a collision such as this, where a moving vessel hits a stationary object or vessel, which we call an elision, prima facie, the liability is 100% on the moving vessel, unless there are any circumstances that unless there was anything that the moving vessel, that the stationary vessel could have done to avert the incident. If so, then parties could have to share liability for all the damage.
Right. So what are the agencies that need to be involved in the fact-finding process and things like that?
In an oil pollution incident such as this, the International Tankers Owners Pollution Federation Limited, or what we call ITOPF, would have to be involved.
Right.
The incident would have to be reported to them, and they usually are heavily involved in the claims analysis.
Okay, so Ms. Tan, can these claims be made against damage to the environment and the biodiversity? Because we saw our ministers there also talking about the damage to the environment and biodiversity not really emerging for another 3 months, perhaps. So is there a limit into during which claims can be made, and can they make claims on those sort of nature?
It is possible for claims to be brought for such damage, but the difficulty often is in quantifying the losses arising from these. Yeah.
What if they can? What if they can say an entire species has been wiped out? Is there a precedent for that?
Such cases are rare, but there have been other cases. There have been other cases where where governments have succeeded for bringing claims for damage to their coral reefs and environment.
Right. Okay. So there is a possibility there.
Yes.
The cleanup operation itself, they deployed booms, extra labor. As we heard the men there saying how they worked through the night, through very difficult weather conditions. Are these the kind of things that will come into play as well? Because
yes. The Maritime Port Authority of Singapore, MPA, can claim for these expenses against the owners of the bunker tanker, including, so they can claim for the cost of deploying specialized equipment. The cleanup could have been subcontracted to other agencies or salvors, and the government can pass on the claims, the cost of engaging these subcontractors. They can also claim for manpower costs incurred in getting the MPA personnel involved in handling the incident.
Okay. The oil spill has reached other countries.
Yes.
It's gone to Johor. What happens in cases like this when beaches in neighboring countries are affected?
So generally speaking, the parties in these neighboring countries can also bring claims against the bunker tanker vessel and the insurers. There is the International Convention on Civil Liability for Oil Pollution Damage, which may allow the owners of the bunker tanker to limit their liability and allow them to set up a compensation fund. So parties in these other countries can also bring their claims against this compensation fund.
Wow, very complex. It sounds like it. Okay, let's bring it back to the man on the street, okay, so to speak, the man on the water. What I mean is the businesses who have to operate the boats, who operate the restaurants around the beaches, people like that. What recourse do they have? Can they go and make their own claim?
Yes, generally speaking, they can. It really depends on what is the loss that they have suffered and whether it is attributable to the incident. In a very major incident like this, there will be a wide range of people, of businesses that could be affected. So, for example, we could have a restaurant that's operating at East Coast Park or at Sentosa, and they could have had loss of revenue because the beaches were closed. So they may wish to bring a claim for loss of revenue, but whether they can or not, it really depends on the exact facts and circumstances. A party that maybe would have more a direct loss arising from the incident could, for example, be fish farms whose fish stock have been depleted, and arguably there could have been some physical damage to their property.
I think generally the farms were said to be safe, but there are so many other businesses that are connected with this that could very well be impacted. Okay, thank you so much for coming in and speaking with me, demystifying all the legal jargon for us.
Thank you very much.
I've been speaking there with maritime lawyer Tan Shwe Ting from law firm Sharp and Jaggard.